Okay, good morning, everyone. I'm Judge Jackie Powell, and we are in first appearance court. Today, we will discuss probable cause, and then we will also talk about release conditions. Please note that today is not your trial date, and so I encourage you not to talk about your case on the record because everything in this courtroom is being recorded and can be used against you at a later time. If you are represented by counsel, either from the public defender's office or if it's private counsel, they are here, they'll come to the courtroom, they'll be able to speak on your behalf. For those of you represented by the public defender's office, I do have an attorney sitting in the courtroom with me, as well as at the main jail, there's an attorney. You may want to check with those attorneys before saying anything on the record. Please also note that we do have the attorney from the state attorney's office here in the courtroom as well, and they are able to provide any information in regards to you personally, if there are any priors or anything like that. We also have in the courtroom confinement status, pretrial supervision services, and of course, we have the clerk of court who maintains the records during these proceedings. For those of you in the courtroom, just to let you know that those of you who have signed in, they don't bring all the persons in at the same time. So depending on where the person you're here for is on the docket, they may not be in the room immediately. And so if they're further down in the docket there, I can tell you that someone signed in with someone on page 29 or 27, it looks like. They're not going to be there for a little bit. Okay, so just so you know, and I'll try and do everything as possible to get you out, but we do have a big docket and we will work through it, okay? So let's begin this morning with Keona Petty.
She's here, present, Judge Amain.
All right, Ms. Petty, you are before the court this morning. Count one is possession of cannabis, 20 grams or less. Count two is fleeing, attempting to elude law enforcement. Count three is touch or strike battery. And the court does find probable cause, and I'll hear from the attorneys in regards to bond.
Your Honor, the state would be requesting a $3,500 bond on count two in order of no contact. Law enforcement arrived to the scene to investigate the domestic violence battery, announced their presence to Ms. Petty. She informed them that she was not going to stop, and she drove off at a high rate of speed, and law enforcement was unable to apprehend her, and she was only able to be brought into custody upon the filing of the not in custody information.
Okay,
Who's here?
I'm sorry. Are you here on this
He's
case?
all alone, so.
Well,
Might be
if you need to speak, you need to let the deputy
It's
know,
all-
and then you need to
scroll
walk
down,
up
scroll
to the
down.
podium, to the lectern and speak, okay?
Could you call Andrew to see if- I know, I'm curious.
All right, good morning, ma'am.
How you doing?
I am well.
I'm here in regards of Keona Petty also. And I see they say 3,500 for her
Yes.
bond, and there's no way she can get a lower bond than that?
Well, that's what we're discussing now. So the state gets to tell me what they're looking for.
Oh, okay.
Her attorney gets to talk and tell me her situation.
Okay.
You're here, I guess you're the persons who will be helping to post the bond. You can tell me what you have to tell me, and then I'll make a decision. Okay? All right.
Judge, from what I spoke to Ms. Petty about, $3,500 is going to be financially out of reach for her. And from what I believe I heard from her sister-in-law, I believe that's also going to be out of reach for her family. Having said that, Judge, my understanding is this is the first time she's ever been arrested in her life. She's a registered voter. She's 24 years old. And as I said, she's been living here her whole entire life now. She just got a great new job. She's been there for about 6 months working at UPS, making about $13 an hour. Now, I understand, I believe counts 2 and 3, the date of incident, I believe, are sometime in April. My understanding is that her and the alleged victim on count 3 have since, I guess, reconciled. They're with each other, Judge, and there's been My understanding, no further altercations or anything like that. Having said that, Judge, now, she lives in Sunrise with her mom. My understanding, Judge, in speaking to her, she believes that maybe if the court were inclined to set a bond as far as $1,000 on count two, with the $1,000 in count three, that would be a 2,000. Hopefully, by going through and using the services of bondsman, they'll be able to afford that. So that's what the defense would be asking for at this time, Judge.
All right, ma'am, you took a seat. Is there something else you wanted to say in regards to the bond? Okay, all right, so finding probable cause on count one, the bond is $100. On count two, $1,000. On count three, $1,000. And I am gonna order no victim contact until further order of the court, okay? All right, good luck. Nicole Tinney?
She's approaching, Judge. She's here present. Come on up, ma'am.
I'm sorry, what was that? Okay, all right, ma'am, you are before the court this morning for one count of DUI with a breath level greater than .15. Count two is DUI, alcohol or drugs. The court does find probable cause. I've been advised that your bond has been posted. Okay?
Awesome. Thank you. Good luck, ma'am.
Alexandra Dominique,
Medical reset.
okay? Laura Lee Antonelli Carroll. Antonelli Carroll is the last name.
North Broward, I believe, Judge.
I'd like to know if her bond has been posted.
All right, ma'am, you're before the court for one count of possession of THC. Count two is DUI, alcohol or drugs. Count three counts three and four are traffic infractions, not for magistrate. Count five is possession with intent, to use a Schedule II hallucinogen. All right, the court does find probable cause. Do we know if Miss Antonelli Carroll's bond has been posted? Well, it's Antonelli hyphen Karol. It's not showing yet.
All right. What Miss Antonelli Carroll indicated to me is that her husband is posting her bond, Judge.
All right, so the standard bonds are in place.
All right, and I am going to call your husband to make sure, okay?
Can you verify the phone number?
I've got 954-803-5534.
Yeah, that's mine. It's 5318. I knew I gave you mine. I always do that.
5318.
18. Correct.
Okay, I'll call him.
Okay, thank you.
You're welcome.
Right there.
All right, let me call this one on page 10. Charles Rosali.
He's approaching, Judge. He's here at Maine.
All right, Mr. Rosali, you're before the court this morning for, charge one is domestic battery by strangulation. Count two is battery causing bodily harm, domestic. Ma'am, I'm gonna ask you to put the baby, have the children sit, please. All right, and I'll hear from the parties as to bond.
Speak?
Not yet.
Okay.
Your Honor, I'm gonna be requesting a $10,000 bond on count one, $1,500 bond on count two, no victim contact, pretrial release with a GPS monitor. This is based on the allegations in this case. Also, Mr. Rosalie was arrested in July 2017 for domestic violence battery against the same alleged victim. The allegations in that case was in the presence of the three children. He struck the victim, grabbed her by her hair, and at one point threatened to kill her. The case was dropped, Your Honor. I would also ask, and I know it's part of the no contact order, but if the court verbally order that Mr. Rosalie's not to be in possession of any firearms, weapons, or ammunition, it's mentioned in the report from 2017 that 3 firearms were recovered in the home, and they ended up being given back to Mr. Rosalie once the case was dropped.
Okay. All right, ma'am,
Yes,
who are you?
I'm his, I've been with him for 8 years. I'm his girlfriend. We have 3 children together.
Are you are you the alleged victim in this probable cause affidavit?
Yes,
All right, so ma'am, I'm gonna tell you, you don't have an attorney this morning, and you're,
I understand, but he's the sole provider of the
okay,
family. I
well,
have a
you let
son
me
that's sick
finish,
with
let me
leukemia.
finish.
Yes, ma'am.
Let me finish, so you understand what I'm telling you this morning.
Yes, ma'am.
I don't know what you said to the police officers, and I can't give you any legal advice.
Okay.
But I also want you to know that anything that you say does not only apply to the defendants, anything that you say today can be used against you at a later time.
Yes,
Okay, so I am going to ask you to raise your right hand if you understand that.
I do.
And do you swear or affirm to tell the truth?
yes, I do.
And then put your hand down, and please state your name for the record.
Veronica Konechny.
Okay,
Sure.
Ms.
Dr.
Konieczny,
Solomon.
what do you wish to tell me?
I wish to tell you that Charlie and I have been together for 8 years. We have 3 children. My son has leukemia. He goes in and out of the hospital 3 times a week. He's the sole provider of the family. I need him to be released. I need him home with the children. I need help with the kids. He's all we have. We're a family.
Okay. All right, Mr. Romero?
Judge, in speaking to Mr. Rosalie, he basically echoed what the alleged victims stated. My understanding, Judge, is, as you heard, Mr. Rosalie is not a convicted felon. He's 55 years old, been living in our community now for about 22 years. What he does in order to help his family out is he does odd jobs. He fixes washing machines. My understanding is they all live together. They have 3 children, and their 4-year-old is battling leukemia, and they're constantly going to and from doctor's office, and that's probably what is preventing Mr. Rosalie from having stable employment. Now, he lives in Tamarack, where he's been renting at for a period of time, and their monthly rent is about $1,675 per month. Now, his landlord, from what he advised me, knows as far as the family situation, as far as the health crisis that the child is going through and their financial struggles. So that landlord's been extremely lenient and helpful, and basically with the rent. Right now, from what Mr. Rosalie advised me, he's basically indigent, Judge.
I've got to take care of my family. We'll take care of the rest of this later date. It's just right now, I got to get back to my family. The case will be taken care of the other date. I promise you there'll be no issues.
Judge, and in speaking Mr. Rosalie, and from what I believe the alleged victim, Veronica, my understanding is I believe she is going to go to the state attorney's office and wants to file a waiver of prosecution.
Yes.
Judge, so I'm asking you to take all this into account in determining reasonable release conditions for Mr. Rosalie.
All right. Ma'am, you can take a seat, please.
Thank you.
All right, this morning is not the trial. It is the first appearance. It is my, role this morning to make a probable cause finding and to determine release conditions. And I do have the obligation to take into consideration anything that I've heard, in regards to this situation. And based on what I've heard this morning, and based on the probable cause affidavit, I am going to impose a $5,000 bond on count one, a $2,500 bond on count two, and until further order of the court, I am going to order no victim contact.
Your Honor, and as far as firearms,
No firearms or weapons, Mr. Rosali shall not have any firearms or weapons until further order of the court.
thank you, Your Honor.
Okay? All right. Okay.
She knows how to.
Okay, on page 4, Tamisha Wilson.
Ms. Wilson is approaching, Judge, here at Main.
All right, Ms. Wilson is before the court this morning for count one, is possession of burglary tools with intent to use. Counts 2 through 10 are burglary, unoccupied conveyance unarmed across county lines. Count 11 is false ID given to law enforcement officer. Counts 12 through 20 are criminal mischief charges. And counts 21 through 23 are out-of-county felony holds. Those are not for magistrate. Those have $10,000 bonds attached to them out of St. Lucie County. Okay? So the court does find probable cause, and I will hear from the parties as to bond on the other counts that bonds need to be attached.
Judge, I did speak with the family, and we discussed counts 21, 22, and 23. And I explained to the family that there wasn't anything the court could do about those bonds on those out-of-county holds. And they're not going to be able to post that bond in any event. So I believe that Ms. Wilson will be a guest of the sheriff's office for the foreseeable future. There are also other issues involving Ms. Wilson that need to be addressed, and our office will be looking into those issues as well.
Okay? Good morning, folks.
Good morning, Ms.
Ma'am, I see you raising your hand.
Yes, ma'am, I've been dealing with Misha now for like 5 or 6 years, and, she normally a good baby when she's medicated. She do have mental issues, and, I was trying to see could they lower the bond so she could go back up this way, and then I'll bring her to court, I promise, every court day. I promise, I'm gonna let her live with me till she get back on track.
Okay.
Please.
Yeah, she hasn't been taking any of it.
She's been taking none of
Well,
that.
as you heard, she already has a $30,000 bond from St. Lucie County.
I know, but
That's nothing that I can do anything
know.
about,
I
okay?
already
That's
know.
with St. Lucie County.
Yeah.
And at this point in time, we have 20 other counts where bonds need to be imposed. So I'll hear from the state and from the attorney.
Like the bonds for all of be placed into one?
Or could you go down some so we can try to
Oh,
work?
we have, it hasn't been set yet. That's what
Oh,
we're
okay.
here to do today. Okay,
Yes, ma'am.
it's okay. All right,
Your Honor, the state is going to be requesting a $2,500 bond on each burglary. I am concerned that Ms. Wilson Williams and her two co-arrestees were in a vehicle that was already being, that surveillance was already being conducted on by both Broward's Sheriff's Office's burglary apprehension team and the Palm Beach Sheriff's Office. It's alleged this vehicle was involved in burglaries in Palm Beach County as well. I would note, 9 separate cars at 2 locations were broken into. As you can see, this is all done while she has a pending case for similar offenses out of St. Lucie County. And I would note, since it was mentioned that, assurances to the court that she would appear in court, she was just arrested April 16th of this year in Palm Beach County on failure to appear warrants for false ID to law enforcement and let's see what other charge. I would also note she was arrested in December of 2018 in Riviera Beach for contempt. She was arrested in July in Palm Beach County for violating release conditions. She had a possession of cocaine and domestic violence battery, 2018 in Palm Beach County.
She never been convicted.
okay.
Judge, as you heard, she's grateful that her family's here for support. My understanding is Miss Wilson does not work. She gets a disability. She's 19 years old. She lives with her sister, who's court. Judge, as far as Miss Wilson goes, she's basically financially indigent. We're going to be asking that the court consider setting a bond on counts 2 through 10 of $1,000 on each count, Judge.
Okay. All right, finding probable cause, I am going to impose counts 2 through 10, $1,000 on each of those counts. And then the other, bonds will be in place, so count 1 will have $1,000. Counts 2 through 10, $1,000. And then, all the other standard bonds that are in place, okay?
Thank you.
Judge Parker, could you make sure she get into the mental health thing for me, please?
I can't make
Yes,
sure.
I'm gonna look into that. and I'm
Okay,
gonna
then.
need-
Thank
I'm gonna
you.
need your name and number. if-
Okay. Godmom.
All right, Chelsea Camacho.
She's here present, Judge, in Maine.
All right, Ms. Camacho is before the court this morning. Count 1 is resisting officer without violence. Counts 2 and 3 are out-of-county felony holds. Counts 4 and 5 are felony violation of probation, which has no bond holds. Those holds are out of Miami-Dade. The court does find probable cause. Does anyone wish to be heard as to bond?
Yes, Judge, on the Broward case, the misdemeanor offense, I'm going to ask the court to consider an ROR so that Dade County can pick her up.
Okay, I'll ROR on count 1. Okay, Chriselle Akers.
North Broward.
All right, Ms. Akers, you're before the court this morning for neglect child without great bodily harm, and the court does find probable cause. I'll hear as to bond.
Your Honor, I'm requesting a $5,000 bond in order of no victim contact. I believe these allegations are aggravating in nature. Just noting, after she was confronted by neighbors that found her child just wandering in the street, and then she came home from purchasing alcohol and was confronted with the possibility that her child could have been hit by a car, her response was that, well, she just won't have her then. Her criminal history: 2015 disorderly conduct, 2015 resisting without violence, 2013 assault, resisting without violence, violation of pretrial release conditions, that being a no contact order, 2012 battery, 2012 trespass, 2009 unlawful use of false name ID, 2008 battery, 2007 DUI with the breath alcohol above a .2. Your Honor, it is also a cause for concern. It appears that the officers, at the conclusion of their investigation, determined that Ms. Akers was making up allegations that the father of the child had committed a battery against her.
Okay. Tari, do you want to say anything in regards to Ms. Akers?
What you're asking me, Your Honor?
No, I'm asking the attorney.
Oh.
Judge, the only thing I show on Ms. Akers here is that we were going to ask the court to consider pretrial release for her. She has been a resident of Florida all of her life. She's been living in the same location since February with her husband and daughter. Her husband works long hours, long days. He makes approximately $800. I'm sorry, how much did you say he made, Ms. Akers?
The new job he was supposed to start today is a salary of starting at $500 a week.
$500 a week. They don't own, their rent is $800 a month. She has had some contact with the criminal justice system, but I believe her last contact was back in 2015. I can call her husband to see what her husband can do about bond. But as I understand it, and as the court just heard, he's starting a new job at this point in time. There's not a lot of money saved. So I would ask the court to consider pretrial release for Ms. Akers.
And Your Honor, and a couple things. One, I would be asking actually for bond plus pretrial with random testing. It does appear to mention that she was heavily intoxicated, and I bring that up because she just advised the court that the father of her child starts his job today. But it notes that yesterday he left the house at 9:45 to go to work and came back at 6 o'clock. I don't know if she even realizes that.
I do, Your Honor. That's the job that he's currently been working at.
All right, well, the allegations in this affidavit are of concern. We have a minor, a 2-year-old walking around with no supervision, as the court does find that to be alarming and concerning. I am going to impose a $5,000 bond, also with a level 2 GPS, random testing, no alcohol or intoxicants.
Your Honor, does that include no victim contact?
Victim contact until further order of the court.
Does that mean that I can't see my daughter?
Right.
But if I'm the only one, it's only us three, me, my husband, and our daughter. And while he's at work, we don't have anybody else, any family or anybody. So I would be the one responsible for for taking care of her day in and day out.
Ma'am, I would tell you to speak with your attorney. Again, these allegations are that a 2-year-old is walking around, someone found the child, brought her back. Please speak with your attorney so that you understand exactly what needs to be done here, okay?
Your Honor, just for the record, I'll contact the arresting officer to make sure the Child Protective Services was contacted.
Okay. All right, good luck.
What was the bond you said, Judge?
5,000 with level 2 GPS.
Okay, thank you.
All right, someone signed in for Debbie Thomas.
Yes, Judge, he just stepped outside.
Okay, that's okay.
Hold on, Your Honor.
That's okay, we're waiting for her attorney to come back in the room.
Good morning, Your Honor.
All right, on, Mr. Shades, am I to assume that this is you?
Perfect, thank you, Judge. That's
You
true.
didn't put your name, or
Oh, I'm
anything.
sorry, Judge.
On page 12, James Ferguson.
Eric, yes,
He's here, present, Judge, I mean.
And then, Mr. Romero, if I can let you know that on page 27, there is Ulysses Rikison. If we can get him in the room at some point in time, you'll let me know, okay?
The deputies are on it right now, Judge.
All right, thank you. So, Mr. Ferguson is before the court, for 2 misdemeanor capuses. Both are for petty theft. And one is a municipal ordinance and one's a state charge. What does Mr. Ferguson want to do today?
Judge, it's me, Mr. Ferguson. He wishes us to resolve this matter today.
That's the same, Judge.
All right, on the state?
One moment, Your Honor. Your Honor, the documented offer from, the offer from the state is adjudication 5 days in county jail. And the allegations in this case, this was the second Walmart he stole from in the same day. He went to this Walmart, got caught stealing, was given an NTA. He then later that same day went to another Walmart, was arrested for theft, and then pled out the next day at first appearances for time served.
Okay. And Mr. Shades, did the city have something that they are offering?
The same thing, Judge, but he has court tomorrow as well. For us.
Right,
So if it goes to the division, we could probably handle it tomorrow.
okay. All right,
Judge,
yes.
I apologize. I didn't hear what was going on in reference to count one.
Well, it's 2 petty theft, and the allegations are, this is the second Walmart, that he stole from. He pled one out when he came before the court, and then there's this other one. Plus, he has also this municipal ordinance, and it's the same charge, it's a petty theft. So the state was asking for 5 days, and the city's asking for it to go to division, so that's where we are.
Get the button.
Couldn't hear you.
I'm sorry. So the city's asking for time served?
No, for it to go to the division
He
judge.
has court tomorrow.
I know Mr. Ferguson was interested in resolving this matter and accepting the 5 days. That's what he just told.
All right. Well, just so he understands, because now we're before one is a city, but I don't know how many prior petty theft charges he has. So, did you have that conversation with him as
That's
to,
all I had on 2 charges right there.
I'll talk to him right now, Judge, but I know if he's,
And I
one
think,
moment,
and he
Judge.
already pled out another petty theft before, so.
So it's probably gonna be out Wednesday. Yeah, picked up yesterday.
Judge, I just talked to Mr. Ferguson. I explained to him that basically if he has 2 prior convictions, the third time he gets arrested for a theft, even if the amount is $1, the state could go ahead and file it as a felony. I've advised Mr. Ferguson, he is aware. He still wishes to resolve the matter, but I believe he wants to ask Mr. Shea on the other charge if he could also consider resolving it, but
Oh,
that's between
well,
him and the state.
he can resolve it. It'll be 5 days concurrent on both.
He wouldn't be getting out today anyways.
I want to take it, Your Honor.
All right, sir, please raise your right hand as best you can. Do you swear or affirm to tell the truth?
Yes.
You can put your hand down. Mr. Ferguson, do you understand everything that's going on here today?
Yes.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
You understand, sir, that you do have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes.
Have you ever been treated for mental or emotional illness?
No.
And sir, do you understand that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter, sir?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence, sir, is adjudication, 5 days in the Broward County Jail with credit for any time you've already served. And that's a run concurrent on both counts.
Judge, I've been advised, Mr. Ulysses is here in court.
Okay, can we handle Stephen O'Neill?
Mr. O'Neill? Mr. O'Neill? What page is Mr. O'Neill on?
15.
15.
15.
I guess this is a reset from the weekend. And
Page 15.
I-
It's a reset. North Broward, Judge.
And, I don't know. Maybe somebody just wrote appoint McLawrence because they know that Mr. McLawrence used to be the,
Actually, it
That's
used to
right,
be, it used to be Babkus for Davy, Judge,
oh,
but it's now me.
O'Neill is a medical reset, Judge.
okay, all right.
That's
Mr. O'Neill, medical reset,
Thank you.
okay? Thank you. All right, and then Ulysses Rikinson? Rikinson Ulysses. On page 27. Who signed in on that case? Or someone would have told me. Anyway. All right. Mr. Ulysses before the court. Count 1 is carrying electric weapon or device. Count 2 is felony violation of probation, which has a no bond hold. Mr. Ulysses does have court tomorrow before his division judge at 8:30, and the court finds probable cause. Does anyone wish to be heard as to bond on one?
No, Judge.
Okay.
Judge, the only thing, Mr. Ulysses, just curious, if his family was here on his behalf or if someone's here?
I don't know. Somebody signed in, but they're not here anymore, so I don't know who it is. Somebody named Erica Joseph. Okay. All right, Cameron Dukes.
He's approaching, Judge, you remain.
All right, Mr. Dukes, you're before the court this morning. Count one is aggravated battery with a deadly weapon, it's domestic violence. Count two is touch or strike battery, domestic violence. Count three is criminal mischief. The court finds probable cause, and I'll hear as to bond.
One moment, Judge. Your Honor, I'm going to be requesting a $5,000 bond on one, $1,500 bond on two, in order of no victim contact. He's 18 as a juvenile. He's had a battery on a felony level offense. He's also, on two occasions, had pickup orders issued, one for failure to appear, the other for absconding.
Okay,
I'd ask
Actually,
the court,
I'm
sorry, go
showing
ahead.
that he's actually on probation, juvenile probation at the moment.
Juvenile probation.
Yes.
Judge, I'd ask the court to make a finding of misdemeanor criminal mischief on count three, as I don't see a dollar amount mentioned in the probable cause affidavit.
That's fine, Judge.
yes. Okay,
Judge, as far as what the state recommended, as far as count two, that's fine. The $1,000 we believe is reasonable. And I believe the standard bond on count three on a misdemeanor criminal mischief, if it's attached with a felony, correct me if I'm wrong, see, most of the time a bond isn't required. What I want to focus on is on count one. I know the state suggests a $5,000 bond. He's going to be asking the court to consider a $2,500 bond. My understanding, him and the alleged victim do not live together. He lives with his grandmother. His grandmother's who he'll be reaching out to help post his monetary bond. From what he advised me, his grandmother's elderly and on Social Security. My understanding, Judge, he's going to school at this time. He goes to Ascend Academy and he's scheduled to graduate next year. He's working. He has two jobs. One, he works at the car wash, and two, he works at a place called Fast Guard Security, where they give him about 2 days a month to work. Judge, that's why I'm going to be requesting for a $2,500 bond on count one.
all right, count one, $2,500, count two, $1,000, and then finding for misdemeanor criminal mischief, I will not impose a bond there. No victim contact until further order of the court. Okay,
And a photo order, Judge.
and I'll sign the photo order. And I don't believe we have Mr. Pierce, correct?
Mental reset?
Yes.
Okay.
Luis Hernandez Nunez.
He's approaching, Judge. Come on up, Mr. Hernandez.
All right, Mr. Nunez, you're before the court. Count one is expired vehicle registration over 6 months. Count two is operating without a valid driver's license. Count three is possession of an open container, which is not for magistrate. Counts 4 and 5 are misdemeanor capiases. Both of those have respectively $250 and $500 bonds. Those capiases are from May 15th, and the other one was issued on May 6th. We're not showing up for a hearing. Okay?
Your Honor, the state would be requesting a $250 bond on count 2. He's out on 2 separate operating without valid DLs. He doesn't appear in court, and is only getting picked up on those capiases because he's unlawfully driving again.
Okay?
Judge, I'm gonna ask the court to leave the bond in place. He's gonna try and get in touch with his family and see if they can come up with his bond.
Let's find out who they're even looking for.
All right, so the standard bonds are in place, okay?
Hello?
All right. Harry Irvin,
Mr. Irvin, come on up, please.
all right, Mr. Irvin is before the court on a misdemeanor capias on a trespassing charge. The court finds probable cause. What does Mr. Irvin wish to do?
He wishes to resolve the matter today, Judge.
All right, does the state have an offer?
All right, you know it's a mood issue, so thank you, though. I'm calling. You can, but I think like that. Sorry. One moment, Your Honor. It's adjudication court cost no return to the Ali Market at 5361 North Dixie Highway in Deerfield.
What is the name of the business?
The Ali Market,
Ali Market?
that's what my notes show, Ali
Okay,
Market.
all right. All right, so Mr. Irvin, did you hear that offer?
Yes,
And sir, do you understand it?
yes,
And you understand that you cannot return to that location?
I understand.
All right, sir, please raise your right hand as best you can. Do you swear or affirm to tell the truth?
Yes,
You can put your hand down, sir. Mr. Irvin, do you understand everything that's going on here today?
yes, I do.
Is anyone forcing you to resolve your case?
No one at all.
Are you under the influence of drugs or alcohol?
Nothing.
Do you need more time to speak with your attorney?
Not really.
And,
Not really?
No.
No? Okay.
and do you understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes.
Have you ever been treated for mental or emotional illness?
None at all.
And sir, do you understand that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
I do.
What plea do you wish to enter, Mr. Irvin?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given, and your sentence, sir, is adjudication, time served, and no return to that location. Do you understand?
Good luck, sir.
Okay. We have the Spanish interpreter here. Who needed the Spanish interpreter?
My understanding, Mr. Jose Arias on page 28, Judge.
All right, good morning. Do you swear affirm to translate from Spanish to English and English to Spanish to the best of your ability?
I do, Your Honor. For the record, Igor Felicioni.
Good morning.
Good morning.
All right, Jose Arias,
José Arias,
you are before the court this morning.
usted está frente a la corte el día de esta mañana.
Count one is grand theft.
por un cargo de robo de cuantía significativa.
Counts 2 and 3 are felony violation of probation.
Los cargos 2 y 3 son violaciones de probatorias.
Both have no bond holds.
Ambos cargos exigen una retención sin posibilidad de fianza.
One is an interstate hold.
Una de las cuales es una retención interestatal.
And count 3 is a Collier County hold.
Y el cargo número 3 es una retención emanada del condado de Collier.
The court finds probable cause.
La corte halla causa probable.
Does anyone wish to be heard as to the bond on count 1?
¿Alguien quiere ser escuchado acerca de la fianza del cargo número 1?
Considering the no bond holds, no, Your Honor, not at this time.
Su señoría, considerando que hay dos órdenes de retención sin fianza, en este momento no.
Okay, so the bond on count 1 is $1,000.
Por lo tanto, entonces, la fianza en el cargo número 1 permanece en $1,000.
All right, good luck, sir.
Buena suerte a usted, señor.
Does anyone else need a Spanish interpreter?
¿Alguien más necesita los servicios de un intérprete español?
From what I've been advised here, Judge, no one else that's here.
Okay. All right, thank you.
Have a wonderful morning, Your Honor.
You too. All right. Do we have, Mr. Romero, do we have everybody in the room yet? No?
So I believe the cutoff is page 24.
Oh, okay. So on page 20, we have Trayvon Major.
He's here present, Judge. Mr.
All
Major,
right.
come on up, please. You have family here, sir.
All right, Mr. Major is before the court this morning. Count 1 is possession of burglary tools with intent to use. Counts 2 through 10 are burglary, unoccupied conveyance unarmed across county lines. Counts 11 through 19, criminal mischief. And the court finds probable cause. Here is the bond for 2 through 10. Ladies, good morning.
Good morning.
Is there something you wish to say?
Well, if we could, we could bond him out as long as, if, with the bond that he has now, with the charges that already have bonds, we could get him out. But, the extra bonds, it might be a minute before he could get out. And, all the other times he's been out on bond, they've been paid, and he appears to court. So, if, he could get out on bond and then keep coming to court for whatever charges it is, I can make sure that he comes, and I can ensure that he pays, his bond.
Okay. And how are you related to Mr. Major?
That's my boyfriend.
Okay. All right, State?
Your Honor, again, I'd be requesting a $2,500 bond on all the burglaries. The same factual argument as his co-arrestee. There is a concern coming down from another county, breaking into 9 separate vehicles at Broward. I see that juvenile pickup orders were issued twice for absconding, fleeing and eluding, battery, criminal mischief. Also showing
Okay.
Judge, in speaking with Mr. Major, where he works at a labor pool, so depending on the type of work, it's anywhere from $60 to $75 a day when he finds work. He's 20 years old, been in South Florida his whole life. He lives in West Palm Beach with his grandmother. My understanding, Judge, he's has a clean adult record. I know he appreciates his girlfriend being here. He appreciates that his girlfriend's gonna try and do whatever she can to post his bond. My understanding is, she works at Starbucks, so I don't know if financially she's gonna be able to afford that much. I know the court said $1,000 bond on the co-defendant, Judge. I know my question is, I believe, correct me if I'm wrong, I believe on counts 11 through 19, the co-defendant's criminal mischief was, I believe, $100, and here it's $1,000. Judge, Mr. Major, from his financial position, not knowing his girlfriends, he can't afford anything. I know his initial request was for the court to consider releasing him on pretrial release.
Also, it appears that there is no dollar amount fixed to the criminal mischief charges as listed in on the docket. I know that the allegation is that car windows were allegedly broken, but there's nothing to indicate that it was over $200 worth of damage.
Even though I work at Starbucks, like I still have like the ability like to financially make sure that I can pay his bond, and even though he's not working, like I can still pay his bond like for him for his payments, because like I make decent hours. I make $9.15 an hour. I work 40 hours a week. I get paid bi-weekly, so I would be able to like keep up with his bond payments if he's able to be bonded out.
the reason the criminal mischiefs are charged as felonies, Your Honor, is because it's a second or subsequent offense.
All right, I am going to, counts 2 through 10, I'll impose $1,000 on each count, and the remaining standard bonds will be in place. Okay?
So his bond is like 19,000.
Yes. Okay. All right, Gilbert Hinton.
He's here present.
All right, Mr. Hinton is before the court for a trespassing charge. The court finds probable cause.
Judge, it's been Mr. Hinton. He wishes to resolve this matter today.
All right, does the state have an offer from Mr. Hinton?
One moment, Your Honor. Just checking that.
You gave it to me as an MO.
Because it is an MO. Your Honor, this is it's
Is it a municipal ordinance?
from what I can tell, it is. It's booked that way. The PC affidavit certainly doesn't have a state statute.
No, all right. So if Mr. Hinton wishes to resolve his case today, it'll be adjudication and time served.
Talk to the judge, Frank, and let her know if you want to accept it, okay, sir?
I don't understand what you're saying.
Mr. Hinton,
Yes, ma'am.
what do you wish to do today, sir?
I'd like to get time served,
All right, so that will be the sentence. It'll be adjudication and time served.
yes, ma'am.
All right, I need to ask you a few questions to take your plea, so please raise your right hand. Do you swear or affirm to tell the truth? You have to answer. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, you can put your hand down. Mr. Hinton, do you understand everything that's going on here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
And do you need any more time to speak with an attorney?
No.
Sir, you understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes, ma'am.
And sir, have you ever been treated for mental or emotional illness?
No, ma'am.
And sir, do you understand that if you are not a U.S. citizen, that by taking a plea today could subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter, sir? Guilty or no contest?
No contents.
I accept your no contest plea and find that it's freely and voluntarily given. Your sentence is adjudication and time served. Good luck, sir.
Okay, I'll go home today.
If there's nothing else holding you in custody, yes.
Oh, yeah, ain't nothing else.
All right.
Thank you.
Are the parties ready on Debbie Thomas on page 8? Good morning, how are you?
Chad, good. How are you?
Good morning, Your Honor. Julie Corbin on behalf of
She was where, in North Broward? Paul Ryan?
Good morning, Your Honor.
Good morning, Miss Thomas.
I'm Chad Mason on behalf of Ms. Thomas, and Your Honor, at this time, I'd like to invoke her right to remain silent.
Okay.
She's been a fugitive for the last, since 2016. So, she was just recently picked up. We have, here, who's the lead agent on this case. He spoke with her prior to the arrests being issued, the warrants being issued. She had indicated that she was going to surrender herself. She then failed to appear to surrender herself at the Fort Lauderdale Police Department. She sold her car to a family member and she fled. So I don't know if you wish to hear from the lead investigator, but at this time, this case is a racketeering case. It's multiple counts of trafficking in oxycodone. She's looking at a 15-year min-man on each count of trafficking. The judge had issued initially a $265,000 bond. We're asking that it be doubled in light of the fact that she's a flight risk, and then all other conditions remain intact. If she's able, well, she'll have to have a nebia hearing prior to her being released, so counsel and I would review that together. The case is already filed. It's been filed for years. It's in front of Judge Merrigan. I don't know if Your Honor wishes to reset it in front of Judge Merrigan for the bond hearing. But we're asking that if in any way she receives bond or is able to post bond, that she be put on an ankle monitor and house arrest.
Well, do you have a court date already for at this time for Judge Merrigan? No? Oh, okay.
Judge, the bonds, if you look at this case, are $265,000. Also, the nebia requirement, the passport surrender. She actually does not have a passport, so that shouldn't be an issue. But I believe that those bonds are sufficiently high to assure her appearance, especially considering the nebia requirement and the fact that she has no passport. So whatever flight risk she poses, it certainly isn't going to be fleeing the country by any means. That being said, this is done by an arrest warrant that Judge Bailey signed, and he determined that these were the appropriate bond amounts at the time that he signed it. So we're going to ask that the bonds remain the same, and that I can continue to work with the statewide prosecutor to get the Nebbia requirements filled and to their liking, and then we can go from there.
The information that Judge Bailey did not have at the time was that she was going to flee, and she has fled, and is looking at minimum limit.
Okay. All right, for this morning, the court, I find probable cause, and I am going to leave the bonds that are in place. We say it says $256,000. I thought you said 265, but it's 256.
Sorry, 256.
$256,000
Yes.
at this time,
And
all
there
right?
was a bond order signed.
And and all the conditions that are attached to the bond order that was signed will remain, and you'll have your hearing otherwise before your division judge, okay?
Thank you, Your Honor.
All right, Steve Pierre Louise.
Please approach the judge. You see her at Maine.
All right, sir, you're before the court for disorderly intoxication, and the court finds probable cause.
Judge, in speaking with Mr. Pierre Lewis, he wishes me to ask the court if the court would consider resolving this matter today.
State has no offer at this time based on the allegations that he was harassing women, several women that had their children with him. When a bystander approached him to leave them alone, he punched that individual in the face. His actions in response when law enforcement arrived, I have no offer at this time.
Okay, does he have any priors?
I don't have him in my system, Your Honor. I do not know. I'm showing looks like he resides in New York.
All right, if Mr. Pierre Louis wants to resolve his case, it'll be 5 days in the Broward County Jail.
Yes, sir. Judge, Mr. Pierre thanks the court for their offer, but he wishes not to accept that offer.
Your Honor, state's requesting a
All right.
$500 bond. I'm sorry.
His bond is $500.
Judge, the problem with the monetary bond is, unfortunately, Mr. Pierre
All right,
advised me.
Mr. Romero, I'm done with Mr. Pierre. Okay, next person, Austin Armstrong.
So what's the verdict? What's the verdict?
$500 bond.
How's that? $25.
I know, they raised it right now.
Why? Why you take 5 days in jail when I'm innocent? I told you.
All right, Mr. Armstrong is before the court this morning. Count 1 is DUI, alcohol, or drugs. Count 2 is DUI with damage to property or person. Count 3 is DUI with damage to property or person. Count 4 is failure to use due care, which is not from magistrate. The court finds probable cause. And I'll hear from the parties as to bond.
Judge, in speaking with Mr. Armstrong, at this time, nothing to add. He gave me the phone numbers of his friends and family to see if they can post his monetary bond.
Okay, all right, so the standard bonds are in place. Sherrod Huntley Murphy.
He's approaching.
Mr. Murphy's before the court for count one is resisting officer without violence. Count two is trespassing, occupied structure or conveyance. The court does find probable cause.
Judge, in speaking Mr. Murphy earlier today, he wants me to ask the court if the court would consider resolving this matter today.
Offered be 3 days, Your Honor. Mr. Huntley Murphy was arrested May 21st and released May 24th upon posting a $1,000 bond for grand theft auto.
He wishes to accept the state's offer, Judge.
All right, Mr. Murphy, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
You can put your hand down. Sir, do you understand everything that's going on here today?
Yeah, yes.
Is anyone forcing you to resolve your case?
Nah, but
Are you under the influence of drugs or alcohol?
no.
Do you need any more time to speak with your attorney?
No, everything is good. Resolved. Got it.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
All right.
And sir, have you ever been treated for mental or emotional illness?
No.
And sir, do you understand that if you're not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, Your Honor.
Then what plea do you wish to enter, sir? Guilty or no contest?
Yeah, there's no contest. Let it resolve. Go on.
I'll accept your no contest plea. I find that it's freely and voluntarily given. Your sentence, sir, is adjudication and 3 days in the Broward County Jail. Credit for any time served, okay? Bruce Paul.
He's approaching, Judge, hear me?
All right, Mr. Paul, you're before the court this morning. Count one is aggravated assault with a deadly weapon without intent to kill. Count two is aggravated battery with a deadly weapon. Count three is battery on a person 65 years of age or older. And count four is touch or strike battery. The only thing, I don't see any age.
Yeah, I'm fine with no PC on count three, Your Honor.
Okay. All right. So, no probable cause on three, and, I find probable cause for the other counts.
Nancy, do you have any notes on him? Yeah. Other than the 1989 case. Your Honor, from what I can tell, and I've, pretrial is thankfully looking, no, I see no history. That being said, I'm going to be requesting a bond in the amount of $5,000 on 1, 2, and 4. I find these allegations particularly disturbing, considering that the whole incident was initiated when Mr. Paul poured a beer on a 2-year-old, a beer on a 2-year-old's head. When he was confronted by the child's mother, he pulled a knife, threatened the victim, and then ended up leaving marks on the victim's stomach with the blade of the knife. And then also further noting what BSO encountered when they eventually took Mr. Paul into custody. And I'd also be asking for no victim contact.
Okay.
One moment, Judge. Judge, thank you for giving me that extra opportunity to speak to Mr. Paul. And speaking with Mr. Paul, as you heard from the state, this is his first contact with the criminal justice system. He's a registered voter. He's advised me, and what I'm trying to explain to him today is not his trial. He is denying the allegations and looking forward to having his day in court and show that he was defending himself. Having said that, Judge, he's a veteran. He served in the United States Air Force from 1970 to 1972. He is 68 years old. He's on a fixed income. At Social Security, he gets $1,250 a month. He lives with his wife in Pompano Beach. His wife is basically has been a stay-at-home wife. My understanding, Judge, she's not going to be able to come up with any sort of fund, so she's going to be relying on Mr. Paul's savings in order to pay for the bond amount. Judge, we're going to be respectfully asking the court to consider a $2,500 bond on count 1, $2,500 bond on count 2, and we're asking that the court leave the standard bond in place on count 4. He assures me he will be coming to court because he really much wants to be here to contest these allegations. And we're going to be asking for a photo order so we can photograph the injuries that Mr. Paul sustained. That is what the defense is looking forward to asking for at this time, Judge.
All right, so the allegations that is before the court today, one, that he poured alcoholic beverage over a 2-year-old's head when her mother confronted him and also called over a friend. It's alleged that he pulled out a folding knife and made an attempt to stab victim 2 multiple times in the stomach. Even though it did not penetrate the skin, it did leave marks. And then further, when the deputies responded to the condominium where the defendant lived, he answered the door by standing inside the closed door and making the distinct sound of racking a shell into a 12-gauge shotgun. He was then directed outside by deputies at gunpoint. He came out heavily intoxicated and completely nude, where he was taken into custody. Based on these allegations, the court finds probable cause. I am going to impose $7,500 bond on each count 1 and 2, $1,000 on 4, no PC on count 3, and then I'm ordering no victim contact onto further order of the court. No.
I'm not
They didn't
asking for any
ask.
time.
They didn't ask. Okay, Marco Delva.
Mr. Delva, Marco Delva. You stepped down, recall, Judge?
Okay. Edward Dolison.
Mr. Dolison, come on up, please. He's approaching, Judge.
All right, Mr. Dolison is before the court. Count 1 is possession of MDMA. Count 2 is possession of cannabis 20 grams or less. Count 3 is misdemeanor violation of probation. That has a $25,000 bond attached to it. So the court finds probable cause. Judge Brown signed that VOP warrant February 21st of this year with the $25,000 bond. Okay? And he goes before her tomorrow at 8:30, so I'm leaving that in place. I find probable cause. Count 1, he has a $1,000 bond. Okay? Sibthorpe Clark.
He's approaching, Judge.
All right, Mr. Clark is before the court for 1 count of possession of cocaine. And the court finds probable cause as the parties wish to be heard as to bond.
Yes, Judge. And speaking Mr. Clark, we spoke about the standard bond that's in place. Unfortunately, he's not going to be able to afford to post it. He's homeless. He's looking for work. He's financially indigent. From what he advised me, he knows nobody that can post his monetary bond. He's 26 years old, Judge. We're going to be asking the court on this nonviolent drug offense to consider releasing Mr. Clark on pretrial release with random drug testing.
Okay,
Your Honor, state would oppose. He just got out of jail on April 16th of this year after being county sentenced to 180 days on 2 separate felony cases, one for possession of cocaine, the other for carrying a concealed firearm. He was already out on bond on the carrying concealed firearm when he got arrested on the possession of cocaine and had his bond revoked on the carrying concealed firearm. So my concern there being, he hasn't shown the ability when out on release conditions to stay out of trouble.
okay. So at this time, we're gonna leave the $1,000 bond in place, okay? Garrison Villiers.
He's approaching, Judge.
Mr. Villiers before the court. Charge number 1 is robbery by sudden snatching without a firearm or weapon. Count 2 is resisting officer without violence. Count 3 is trespassing.
Your Honor, based on the allegations, I believe the facts would support robbery without a weapon. The allegation being that he punched the victim in the face and took his glasses.
Right. So as to count 1, it's robbery without a weapon. Okay, I'll hear as to bond.
One moment, Judge. Without. Your Honor, I just see a 2016 resisting charge out of Missouri. Based on the level of violence, I'm requesting a $7,500 bond and no victim contact, no return.
Okay.
Judge, he's 26 years old. He works. He's a truck driver. He has family here in Delray Beach. His stepmother. His girlfriend is here. His girlfriend is who he's going to be relying on monetary bond. From what he advised me, she's a caregiver. So her financial resources are limited. I'm going to be asking on count 1, the court to consider setting a $3,500 bond on Mr. Villiers' behalf, Judge.
All right, finding probable cause, and based on the allegations in this probable cause affidavit, I am going to impose a $7,500 bond on count 1, and the other bonds will remain in place. Okay? Johnny Allen. Mr. Allen is before the court. Count 1 is possession of cocaine. Count 2 is possession of MDMA. Counts 3, 4, 5, and 6 are felony violation of probation. Those all have no bond holds, and Mr. Allen does have court before his felony division judge tomorrow at 8:30. The court finds probable cause. Counts 1 and 2, the bonds are $1,000 on each count. Carlos Izaza.
He's approaching, Judge. Here, man.
All right, Mr. Izaza is before the court. Count 1 is DUI, alcohol, or drugs. 4th or subsequent offense. Count 2 is DUI with a breath greater than .15. Count 3 is driving while license suspended. Count 4 is disobeying a stop sign, which is not for magistrate. The court finds probable cause. And I'll hear as to bond.
One moment, Judge. If Mr. Romero wants to proceed, that's fine. It's going to take me a few minutes to put Mr. Isanza's information in the system.
In this case, Judge, I don't mind going. First, and speaking of Mr. Isanza, unfortunately, well, there's two issues going on. The only person that may be able to post his monetary bond is his mother, who he works with. Who he lives. She babysits for a living, sort of financial resource limited. If she goes and uses services of bondman, maybe she can come up with $200. So that is why we're going to be asking for, on count one, the court to consider a $1,000 bond. Now, he lives in Hollywood with his mother. He's been living there for the past 3 years. He's been here in South Florida for the past 15 years. He works basically painting. He does that part-time. On a great week, he can make up to $400 per week. Judge, when he was arrested, the officer was nice enough to let him write down a number. And I believe from what he advised, he put it in his Jeep. And it's here in property. So what I'm going to ask the court to do is sign an order allowing access to his property so he can take out that sheet of paper to contact that person and post his bond. So we're asking for a $1,000 bond and a property order on Mr. Sanza's behalf.
Wow. Your Honor, the state's going to be requesting $15,000 bond on count one. As you can see, this is his fourth DUI. Your Honor, his most recent DUI was 2017 out of Coral Springs, and he just got off probation. March 13th of this year. He's supposed to be having interlock restrictions for 2 years from the date of his probation, which started March 13th, 2018. So from what I could tell, if he was driving the car he's supposed to be, there should have been an interlock, which wouldn't have even allowed him. So it looks like he may be taking advantage of getting access to a car that doesn't have an interlock. Also, just noting how high his breath is in this case, 0.246, 0.225. In addition to whatever bond the court deems appropriate, and I'm sorry, I'd also be asking for a $2,500 bond on 3, driving on his suspended license that is suspended from his DUIs. I'd also be asking for pretrial with a TAD monitor, no alcohol, no intoxicants, and also in the court order of no driving.
All right, based on these allegations, it is also, some of the priors are also listed in the probable cause affidavit, the 2018 conviction on a DUI, then 2006 out of South Dakota, June 2006, and then December 2006, all DUI charges. That's also out of South Dakota. Driving while license suspended, 2011. Those are the priors that are listed in the probable cause affidavit. There are 3 samples, .246, .225, .234. Based on those allegations, I am going to impose on count 1 a $15,000 bond. And count 2 is $1,000. That's going to also include pretrial supervision with a TAD monitor. Okay, no alcohol or intoxicants. Pat. Okay. Darian Polk.
He's approaching, Judge. You hear me?
All right, Mr. Polk.
Also, the gentleman on page 16, Deborah, is back, Judge.
Okay. All right, Mr. Polk is before the court. Count one is possession of burglary tools with intent to use. Counts 2 through 10 is burglary, unoccupied conveyance unarmed. Counts 11 through 19, criminal mischief, and the court finds probable cause. Are there any different priors with Mr. Polk? Otherwise, I'll impose the same that I did for his co-defendants.
Yeah, I'm checking that right now, Your Honor.
Judge, while you're waiting for state information, my understanding, Mr. Polk, even if the court were inclined to set similar bond conditions, I believe a total of $19,000, that's something Mr. Polk cannot afford. He's asking for the court to releasing him on pretrial release. He's 23 years old, and here his whole life. He lives in West Palm Beach with his girlfriend. Now, him and his girlfriend have been renting the house, and their monthly rent is $657. He works at a labor pool, and that's how he gets the money for rent. She gets disability. So from what he advised me, they're not in a financial position to pay any sort of bond, let alone $19,000. So he's asking the court to consider releasing him on pretrial release.
Yes, Your Honor. I think the court should be aware that Mr. Polk, his juvenile history was so serious that in 2012, actually before he turned 17, he was tried and he was convicted in Palm Beach County of burglary of an occupied dwelling and burglary with assault and sentenced to 4 years in state prison on those charges. In 2016, in Palm Beach, he was convicted of grand theft auto and sentenced to 5 years state prison. He was released from state custody November 17th of last year.
Okay, counts 2 through 10. I'm going to impose $2,000 on each of those counts. And then the other standard bonds will remain in place. Well, let's do Mr. Delva, and then we'll take a brief recess.
Mr. Delva is here, come on up. And Judge, he declined the service of public defender?
No, I changed it to a public defender. I changed it.
Oh, you changed your mind?
You fill it out.
All right, Mr. Delva, you're before the court. Count 1 is possession of cannabis 20 grams or less. Count 2 is possession of drug paraphernalia. And count 3 is driving while license suspended. And the court finds probable cause.
Judge, if the court found probable cause, at this time, nothing to add from the defense.
Okay.
Nothing from the state, Judge.
Okay. Okay, $750 bond. And we'll take a brief recess. Next, we have Kevin Soku.
He's approaching, Judge.
All right, Mr. Soku is before the court. Count 1, resisting officer without violence. Count 2, fleeing and eluding law enforcement. Count 3, leaving the scene of a crash involving damage to property. Count 4, operating without a valid driver's license. Count 5, disobeying a stop sign, not for magistrate. Counts 6 and 7 are felony violation of probation with no bond holds. And Mr. Soku does have court tomorrow before his division judge at 8:30. And the court finds probable cause.
Nothing to add from the defense.
Okay. All right, he has $2,500 on count 2. Okay. Herman Davis.
He's approaching, Judge. He's here in Maine. He declined to serve as public defender pro se.
All right, Mr. Davis, are you hiring a private attorney?
Yes, ma'am.
Okay. You are before the court this morning for charge number 1 is grand theft of a firearm. Count 2 is possession of weapon or ammo by a convicted felon. Count 3 is possession of cannabis, 20 grams or less. Count 4 is an out-of-state felony hold, that is a no bond hold. And count 5 is a possession of weapon or ammo by a convicted felon. All right, the court finds probable cause. And I'll hear from the state as to bond.
Your Honor, the state's going to be requesting a $20,000 bond on both counts 2 and 5. As Your Honor already stated, he has a no bond hold out of New Jersey on a warrant for burglary. In Broward, he was convicted of a robbery with a firearm or deadly weapon from 2010, sentenced to 5 years and 6 months in state prison, and was released January 5th, 2016.
Okay. All right, so, Mr. Davis, you have $1,000 bond on count 1, 20,000 on 2, 100 on 3. You have a no bond hold, on count 4, and a $20,000 bond on 5. Okay?
Yes.
Barry Williams,
North Broward.
I'm sorry?
On Barry Williams, we have a corrected, if we can draw a line through count 9, count 9 has been expunged.
Count 9 has been,
Even though it's not for magistrates,
okay,
it was put on twice.
okay.
That's the corrected figure.
Okay, all right, so, Mr. Williams is before the court. Count 1 is possession of alprazolam. Counts 2 through 8, felony capias, no bond holds, not for magistrate. Count 9 is erased. Counts 10 and 11 are felony capiases, no bond hold, not for magistrate. Count 12 is a misdemeanor capias with a $500 bond attached to it, okay? And the court finds probable cause.
Yes, Judge, I discussed this with Mr. Williams, and
Okay.
we're going to just ask the court to leave the bond on count 1 in place.
All right, and looks like he has court tomorrow and Wednesday, on these matters. Okay? All right, good luck, sir. Anton Harris.
He's approaching, Judge. Come on up, sir.
All right, Mr. Harris, you are before the court for driving while license suspended, third or subsequent offense, and count 2 is failure to register motor vehicle, and the court finds probable cause.
Judge, in speaking with Mr. Harris, him nor his fiance is going to be able to afford the monetary bond. Judge, he's 48, been here over 10 years in our community. He's working. He works for a company called Cardinal Health. His fiance works at Macy's. They live in West Park, where they've been residing and renting at their apartment for 2 years. Their monthly rent is about $650 per month. Judge, he's asking on this nonviolent offense if the court would consider releasing him on pretrial release.
Okay,
This is on Antoine Harris, Your Honor?
yes.
I have no objection.
Okay, so, Mr. Harris, you'll be released to pretrial supervision.
Okay, thank you.
All right, sir, good luck.
Yeah, thank you.
John Moses?
This is Mr. Moses on page 28, Judge, and he declined to serve as a public defender.
All right, Mr. Moses, do you have private counsel?
No, ma'am.
Okay. All right, you are before the court today for 1 count of possession of THC. Count 2 is license plate validation sticker and failure to register motor vehicle. All right. And the court finds probable cause, and I'll hear from the state if they have anything to say in regards to your bond.
No, Your Honor.
No? All right. Mr. Moses, you have a total of $2,025 in bond, okay?
Yes.
All right, sir, good luck. David Baker?
Mr. Baker, come on up, please. He's approaching, Judge.
All right, Mr. Baker is before the court for count 1, possession of drug paraphernalia. Count 2 is a felony capious matter, which is no bond hold and not for magistrate. And the court finds probable cause.
Judge, considering as a no bond hold, nothing to add from the defense.
Okay. And Mr. Baker does have court tomorrow before his division judge, okay? Dexter Fields?
Mr. Fields is approaching, Judge.
Mr. Fields is before the court. Count 1 is grand theft. Count 2 is resisting officer without violence. And the court finds probable cause.
Judge and speaking, Mr. Fields, I'm going to be contacting the mother of his children to post his bond, so nothing to add from the defense.
Okay. He has priors, okay?
He's got a pending case, so there's nothing further from
Okay,
the state.
$1,000. Caleb Charles,
Medical reset.
okay. So Charles been reset. Taryn Vines,
He's approaching, Judge.
Just kept in place.
all right, Mr. Vines has, charge 1, possession of drug paraphernalia, and then 2, 3, and 4 are felony capuses with no bond holds and not for magistrate. The court finds probable cause. I'll leave the bond in place as to count 1, and he has court tomorrow as well before his division judge, okay?
Good luck, Judge.
Deshaun Niederman,
Mr. Niederman is approaching, Judge, and he declined the service as a public defender. Come on up, sir.
all right, Mr. Niederman, do you have private counsel?
I do not.
Okay. All right, sir, you are before the court this morning. Count 1 is battery on an officer. Count 2 is disorderly conduct. Count 3 is resisting officer with violence. And the court finds probable cause as to those charges. Hear from the state.
Your Honor, I'd be requesting $2,000 bond on 1, a $500 bond on 3. I'm showing that Mr. Niederman has a warrant out of New Jersey from 2015. It's a failure to appear on a violation of probation for burglary. I'm also showing priors out of, sorry, one moment, Your Honor. Priors out of the state of Pennsylvania as well.
Okay. So, Mr. Niederman, you have a $2,000 bond on count 1. There's a $25 bond on count 2. And You have a $500 bond on count 3. Okay?
Okay.
Josiah Sosa,
Judge, he's here approaching, and Mr. Sosa also declined the services of public defender.
all right, Mr. Sosa, do you have private counsel?
Sorry?
Do you have a private attorney, or you plan on hiring one?
Planning on hiring.
Okay, you're before the court today for possession of THC. The court finds probable cause. State,
I wasn't gonna be making any requests, Judge.
all right. Mr. Sosa, is there anything you wish to say in regards to setting your bond?
No?
Okay, you have a $1,000 bond, sir. Marcus Warren,
Judge, he's here. He advises he has private counsel, Regina Tumnanaknis.
She's waiting to appear by phone, Judge.
okay. All right, well, let's leave that for last, and I'll call Ms. Sambanakis as soon as we're done with the others. Dennis Smith,
He's in downtown court.
Mr. Smith is in court,
Your Honor,
yes?
I would just ask that the court could, unless the defense has an objection, this is a misdemeanor add charge to a felony case. It's not gonna be resolved here.
Okay.
I imagine he's probably
Is
being
it
arraigned.
correct, charge number 11?
Yes, I imagine he's being arraigned by Judge McCarthy,
All right,
so he'd be advised of the charge anyways.
all right, so Mr. Smith has a possession of drug paraphernalia, charge number 11. Find probable cause, and his bond on that count is $100.
That's fine.
Maurice Thomas,
North Broward.
all right, Mr. Thomas is before the court for grand theft auto. This is this an ad charge?
I believe
Yes.
so.
Number 2 for grand theft auto, how much bond does he already have, or?
He has a no bond hold on count 1 for a violation of probation. I'd ask the court to leave this $1,000 bond in
Okay,
place.
so we find probable cause, and the bond on count 2 is $1,000. Charles Golden, a medical reset, it's a violation of parole. I'm gonna find probable cause, and he has to go before the parole board, okay? Thank you. Mohammed Abosnina,
Yes, Your Honor, he's been reset since middle of last week.
yes?
Just ask that the court could make a PC determination. I have no objection to him having him brought back for bond purposes.
All right, so Mr. Abosnina, I'll find probable cause. He needs to be brought back to court to set a bond. Luis Hosla,
I've been informed bonded, Judge.
bonded, okay. Jermaine Oliver,
North Broward? North Broward, yeah.
thank you. All right, Mr. Oliver, here before the court for 1 count of possession of MDMA. Count 2 is an out-of-county felony hold out of Palm Beach County on a violation of probation. The court finds probable cause. And the bond on 1 is $1,000. Okay? Kenneth Livingston,
Refuse, Your Honor.
Yeah, I spoke with him earlier, and I was advised that he needed to go see the doctor. So I told him he has a no bond hold, and he required some medical attention, so that's why he's not before the court now.
all right, well, he does have a no bond hold on a violation of probation. I am going to find probable cause. He has a bond of $100 on count 2, and he does have court tomorrow before his division judge, okay? All
Yes,
right.
I advised him of that as well.
Okay, all right, what is the phone number that I'm calling now?
It's area code 305
Okay,
776
okay,
0307.
okay,
And that's
All right.
Regina Tombanakis.
okay.
No, someone dropped this off at homicide.
Hello, this is Regina.
Good morning, Ms. Ambanakis. This is Judge Jackie Powell from First Appearance Court. I'm calling you just to let you know you're on speakerphone and we're in open court in regards to Marcus Warren.
Yes, ma'am.
All right. So Mr. Warren is before the court this morning for one count of premeditated murder. And the court finds probable cause, and I'll hear from the state.
Thank you, Your Honor. Eric Linder on behalf of the state. Your Honor, I'm relying upon the arrest warrant affidavit prepared by Detective Edward McCormick of the Lauderhill Police Department. I'm going to be seeking a no bond hold upon the finding of proof evident or presumption great for first appearance purposes only. I know Your Honor has familiarized yourself with the specifics in the 12-page affidavit. I would note, Your Honor, in addition to the factual allegations satisfying the elements of first-degree premeditated murder, I would note, Your Honor, the numerous eyewitnesses to the incident that all identified Marcus Warren as the shooter in this matter.
Okay, Ms. Sambanakis, you wish to respond?
At this time, Your Honor, we're going to just be entering a not guilty plea, and it would be set in the presiding judge for an Arthur hearing for purposes of a bond.
Okay. All right, so at this time, I'll make a further preliminary finding of proof evident presumption great. This is without prejudice for Mr. Warren to have a bond hearing before his division judge based on State v. Arthur, and he will be held no bond until such time. Okay?
Thank you, Judge.
All right, thank you. Good luck.
Bye-bye.
Bye. All right, I believe this is it. Wait for the morning. Thank you, everyone. I'll see you this afternoon.
It's safe for the